state. May I have the appearances, please?
Good morning, Judge Sue Opper, Leslie Basie, and Zach Witchow appearing for the state of Wisconsin.
Good morning, sir. Please state your name for the record.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in these charging instruments, and I do not consent to or agree to being called their name, Your Honor.
All right, the record should reflect that the individual known to this court as Darrell Brooks is appearing in person in custody. I do want to address the case law that was filed by Mr. Brooks. You had indicated there was this United States v. Lopez. I asked you if it was from 1995. Have you been able to look through your documents to tell me which United States versus Lopez?
I have not, but I also cited Hagens versus Levine as well.
I was able to find Hagens versus Levine and Malo versus United States. Also found United States versus Lopez. It had to do with the
jurisdiction.
No, it had to do with a provision in the federal statutes regarding the gun safe free zone and whether that was constitutional or not.
My understanding of that particular case was dealing with the specifics of subject matter and personal jurisdiction, which is something that I have been doing adamantly, asking for the court to provide verified proof of jurisdiction.
Court's not required to do that. I understand what your objection is. It's been noted for the record multiple times. I do want to give the state an opportunity to at least make a record as to their position, and then I'll give you the last word if you want to make a legal argument to the contrary.
I do.
I did review the Lopez case. As the court already indicated, it deals with the Gun-Free School Zone Act. Congress exceeded its authority under the Commerce Clause, and therefore there was no jurisdiction. Malo versus United States. This was a case involving an accident the plaintiff had with an employee of the U.S. Postal Service. The issue became whether or not there was a valid claim against the U.S. Postal Service, and the court held that there was not, and therefore jurisdiction was not conferred. Again, not a case that is on point. And finally, Hagens versus Levine. It was a case in which state of New York regulation addressed New York's ability to recoup some payments from AFDC, I believe. That violated the Equal Protection Clause. The district court did have jurisdiction to hear the plaintiff's claim. Again, I did not find any verbiage from any of these three cases that would raise any type of argument that this court does not have jurisdiction.
Yeah, I respectfully object to that. It's clear that ultimately those cases ended up being voided because there was no jurisdiction. Same thing in this case, how it applies is this court has yet to prove that it has jurisdiction. It has not been proven. There's been no certified document paperwork. There's been no response to the demand for the statement of particulars. I mean, we haven't even established that the plaintiff is a living human being and not an entity. And again, if both cases that were just cited were voided by the Supreme Court for lack of jurisdiction, how is this case any different?
Thank you for your argument, sir. First of all, the Hagens and the Malo decisions, or Malo, these were civil lawsuits. They weren't criminal cases at all. The Lopez decision, while a criminal case, the U.S. Supreme Court struck down a federal statute that had made an offense criminal, and because of that, there was no jurisdiction. There have been no similar arguments made at all. The arguments that you raise related to the Bill of Particulars have all been debunked throughout the ages in the courts of the United States of America. This court will deny your request to dismiss, deny your request for the demand for particulars, your demand for a verified statement, your notice of special appearance.
Your Honor, may I respectfully request a legal reconsideration for your ruling?
No, I just went through my reasoning.
For the record, may I request a legal or factual basis for your ruling?
I just provided the legal basis.
Respectfully, Your Honor, may I ask for a written judicial finding of facts and conclusion of law on this matter?
You may request. That request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal on this matter, Your Honor.
That is not an issue this court would address. That would be for an appellate court.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction.
That request is denied. This is a court of competent jurisdiction.
Based on what law or fact, Your Honor?
All right, Mr. Brooks.
May I respectfully object to that, Your Honor? May I respectfully object, Your Honor, and still ask for verified proof?
Mr. Brooks, I've already addressed that. The request is denied. All right, moving on. Can the state... I'm moving on, Mr. Brooks. Thank you. Attorney Opper, I'd like to address the issue...
Object, Your Honor.
Your objection's noted.
We have received the subpoenas that were provided by Mr. Brooks. There were 12 in total. One of the witnesses on Mr. Brooks' subpoena list does need a Spanish interpreter.
There's a possibility that they will need an interpreter. If that's the situation, then I'm going to require that Mr. Marquez be produced. At that point, you'll be questioning him first, since it would be your witness. I want to make wise use of our resource as it relates to the interpreter. Mr. Brooks, any questions about what I've advised you about?
I want to state for the record that I object to being called that name. I'm a living and breathing human being. I don't know if the clerk received 2 ICF forms that I submitted. One of the ICFs we just addressed, that was dealing with the subpoenas. The other one was dealing with asking for my court docket sheet.
What do you mean by that, sir?
I would like a certified copy of my court docket sheet.
There are docket entries that are part of the electronic file.
Every court proceeding, is that part of the electronic file? What did you just say?
You mean a recording of the proceedings?
No,
or
no,
a record?
no. I want the actual docket sheet from every court proceeding that I've had in dealing with this matter.
Well, you'll have to address that to the clerk of court.
I did.
Okay, so then that's why it didn't come to me and I wouldn't seen it. I'm not the custodian of the record. It's the clerk of court.
It was addressed to Miss Monica Paz.
Okay, that's our clerk of court.
Ms. Grabo, did you see yourself in that video?
Yes, I did.
Let's go back to the beginning, and let's go at about 50% speed.
Objection was the relevance of showing the video to us.
Overruled.
Grounds.
It's relevant.
Grounds.
And we'll play from the beginning.
The vehicle that struck you, do you recall seeing a driver?
No, I seen the red hood of the vehicle.
So you didn't see the driver or anybody in the vehicle?
No, again, I just seen the red hood as it ran into me.
No license plates or?
Nope.
You stated that after you were struck, you got up and ran to your daughter, correct?
Yes.
And you were able to do that with your leg injury?
Yes. I guess that would be the adrenaline going through your body at that moment in time.
When did that pain in your leg set in?
It was immediately.
But you were still able to get up and run?
Yeah.
After you were struck, it would be fair to say that it got louder than what it was before.
After, in the middle of the complete chaos, yes.
With all the noise and chaos going on, do you think it would have been hard for you to hear a horn honking?
I did not hear a horn.
Would it have been hard? The question was, would it have been hard for you to hear it?
Before it got to us or after?
After it became chaotic.
I was not listening for a horn after we had already been hit by the vehicle.
So it'd be fair to say you wouldn't be able to recall. Did you file any claim in this incident?
What do you mean by claim?
Did you file a report as an injured party in this matter?
Yes.
Have you seen or read a complaint in this matter?
What do you mean by that?
Have you seen a written complaint or read a written complaint in this matter? Objection. Grounds.
Mr. Brooks, are you referring to the criminal complaint in this case or something else?
I'm referring to something else, the complaint.
Well, then I'll sustain the objection. It's vague.
I respectfully ask on what grounds, Your Honor?
It's vague.
Do you know of any complaint being filed in this matter?
Objection. Vague.
Grounds.
Sustained.
Grounds.
That's the form of the question.
Did you seek to give testimony in this matter? And who were you informed by?
The district attorney's office.
Did they ever inform you of who the plaintiff was in this matter?
Objection. Relevance.
Grounds.
Sustained.
Are you aware of any plaintiff in this matter?
Objection.
Grounds.
Relevance.
Grounds.
Sustained.
Have you ever talked to the plaintiff in this matter? ever seen the plaintiff in this matter?
Objection,
Grounds.
Sustained. Mr. Brooks, you need to move on to a new topic or I will close the cross-exam.
I will move on. It has to be some type of ground stated other than relevancy or anything like that. The real ground should be put on record, Your Honor. We all deserve to know. The jury deserves to know.
It's not relevant. Move on.
So are you bringing this claim against the accused defendant in this matter?
Objection, vague.
Grounds.
Sustained.
On what grounds, Your Honor?
It's vague.
Have you seek to receive any recovered damages or anything in the matter?
The only thing that we got was help to pay for our medical bills, as that was something that was completely unexpected from a Christmas parade.
Is that through the state of Wisconsin? Are you listed as a plaintiff in this matter?
Am I listed as a plaintiff in this matter?
Are you the plaintiff? Did you file the claim?
Objection,
That's a
relevant.
compound question. Sustained. Mr. Brooks.
Did you file the claim?
90611. Move on.
Do you see the state of Wisconsin present in the court?
Objection, grounds.
Sustained under 90611. I warned you to avoid that topic or I would cease cross-exam, so I'll give you one more opportunity to ask a different line of questioning.
Can you recall why it took a little bit for you to be interviewed by law enforcement?
I'm guessing because of how many people were injured throughout this parade. It did take a while to get around to everybody.
Do you recall stating that you did not see what happened to your daughter? So it would be fair to say if you didn't see what actually happened to your daughter, you didn't see what happened to anyone else.
Objection.
Grounds.
Characterization of the
Grounds.
evidence.
Sustained as to the form of the question.
So it would be fair to say that you didn't see anyone get struck besides yourself.
It would be kind of difficult to see beyond that.
Can I just clarify, Ms. Grabo, the last time you saw your daughter before you got struck, where was she?
Objection. Irrelevant.
Overruled.
She was walking off to the sidewalk to hand out more candy.
Sidewalk on which side of the Burris float?
Objection. Hearsay.
Overruled.
To the driver's
And
side,
where's the next place that you saw Adelia?
I seen
Hearsay.
Adelia.
Overruled.
Say that she didn't see anything.
It's not hearsay, Mr. Brooks.
That's the definition of hearsay.
Mr. Brooks, it's overruled.
On what grounds, Your Honor?
Where was she in relation to the truck that was pulling the float?
Objection. Hearsay.
Overruled.
On what grounds?
It's not hearsay.
What about before you got struck? Did you hear the sound of a horn?
I did not.
Hearsay.
It's not hearsay. Overruled.
Are you familiar with the program, the Waukesha Blazers Youth Baseball Program?
Yes,
Irrelevant.
Overruled.
Yes, I currently serve as the president.
And if you can recall, was the vehicle in the middle of Main Street?
Objection. Hearsay.
Overruled.
From what I remember, yes.
Was there a group immediately after the Blazers team?
Objection. Relevant.
Overruled.
Was it coming on the south side of the street, the middle of the street, or the north side of the street, which would have been to your right?
Objection. Hearsay.
Overruled.
It was middle, and then it moved to the left to go around our truck.
Do you know if Caden got struck by the red SUV?
Objection. Hearsay.
Overruled.
Yes, he did.
What injuries did he have?
Objection. Hearsay.
Overruled.
Is it correct that that form says, after that I saw the car drive past us on the left, striking two of our players, Tucker and Jackson Sparks?
Yes.
Objection. Hearsay.
Overruled.
Yes. Hearsay.
Overruled.
Now, after the car went to the left side of the Blazers truck, striking the kids, did you see the path that it took?
Objection. Hearsay.
Overruled.
Yes, I remember it going back to the right side of the road after.
Can you estimate approximately how fast it was going when you first took notice of the red SUV?
Objection. Hearsay.
Overruled.
It's 25-mile-an-hour speed limit, so faster than the speed limit.
And I'm assuming when you're in a parade, although the speed limit on that road might be 25 miles per hour, you're not going 25 miles per hour. Would that be a correct statement?
Absolutely.
Objection. Hearsay.
Overruled.
The line on the left side of that diagram, would that be the area in which each of those people were struck?
Objection. Hearsay.
Overruled.
Yes, it appears accurate.
Does it accurately depict what occurred shortly before, during, and after the red SUV struck the Blazers?
Yes.
Permission to publish and admit Exhibit 148.
Objection.
Permission to publish is granted.
On what grounds? What is the relevance of showing the entire video?
Overruled.
What grounds?
Relevance.
What grounds?
That is the grounds. Relevance.
it was played until the end. Does that accurately depict the path of the vehicle as it was striking the Blazers members?
Yes.
Nothing further, thank you.
I'm going to take a mid-morning break at this point. All rise for the jury, please. I will have the jury brought out and we'll continue with the questioning of this witness.
Judicial determination you made about the jurisdiction.
I thought I was very clear.
So will proof be validated?
Your request is denied.
On what legal basis, Your Honor? Is that a judicial determination? So that is a judicial determination?
All rise.
Mr. Brooks, you may start your questioning of this witness.
Just a second, I'm sorry about that. I just needed a second. I apologize to the witnesses. A little emotional right now for me, so I apologize to the court as well for the delay. You stated that you did not see the vehicle strike the children that were in front of you. You said something to that effect. Would that be fair to say?
You'd have to be more clear.
You said something to that effect.
To what effect?
Sitting here today that you do not recall seeing anyone struck ahead of you. But then you also stated that you did see who was struck ahead of you.
Is that a question?
Would that be fair to say?
When I was there or the video, what are you talking about?
At any time when you was there.
When I wrote my statement, I wrote what I remembered at that time.
Would it be fair to say that as you sit here today that anything about your statement may have changed?
Nothing has changed.
So your testimony here today would be accurate to what you reported?
Everything I said has been accurate.
Do you recall saying in your interview with the DIC that your 11-year-old son and 9-year-old daughter suffered minor injuries in the event?
I remember saying they were injured.
Do you recall saying that the injuries were minor?
No.
Not direct the witness to the statement.
Is it his statement or a summary?
It's not his statement, it is a statement from DCI. The DCI agent spoke with Mr. Rogers and wrote down what he believed was said to him. I would object to this being characterized as this witness's statement.
Grounds.
If he would like to call the DCI agent, then he may do so.
Grounds.
I'm going to sustain the objection.
Do you recall stating that the injuries were minor?
No.
Any reason why they would report that you said that?
I don't know, you'd have to ask them.
Any reason why they would believe that that's what you said?
Objection.
You reported. Grounds.
Sustained.
Were you injured in any way?
No physical injuries.
Do you recall if anyone else besides your children who were injured?
I remember lots of people who were injured.
Do you recall?
I just answered that.
Specifically, you remember who besides your children?
You want me to list all of the names that were injured?
Just rough estimate.
10 to 15 people that I saw.
That you actually observed?
Yes.
Did you render any assistance to any of those people?
No.
Any reason why not?
My daughter was missing.
So it'd be fair to say at that moment your concern was your daughter that you didn't retrieve?
My concern was for everyone that was just struck by the vehicle.
Including your daughter that was missing, right? Did you file any reports?
Just what you had in front of you that you're reading from. That was my statement.
No. Did you file any injury reports?
Objection, that's a big question.
Grounds.
Sustained.
You know, usually if there's an injury, you will file a complaint. To the best of your recollection, did you file any complaint?
I wouldn't consider it a complaint. I filed some paperwork saying that my children were injured.
Do you recall if that was a complaint? Was it a claim in any sort of way?
Yes.
Do you recall what the claim was?
It was to help with any medical bills that arose out of this situation.
So it would be fair to say that you had a financial interest in this incident?
Objection. This characterizes the testimony.
Grounds. I believe it's relevant to the fact that bills were needed to be paid.
Overruled.
So would that be fair to say that you had a financial interest?
I would say sitting here today, I didn't care if it got approved or not.
So if it had gotten approved, would you have been able to do it yourself, or would you have seek to do it yourself?
Objections, relevance.
Grounds.
Sustained.
Would you have paid the medical bills yourself,
Yes,
regardless to price?
I generally pay my bills.
Not the rest of your bills, specifically that matter.
Objections, relevance.
Grounds.
Sustained. Move on, Mr. Brooks.
Did you seek to testify?
No,
May I ask why you agreed to testify if you didn't seek to?
Objections, relevance.
Grounds.
Sustained.
Are you aware of the plaintiff in this case?
Objection, relevance.
Grounds.
Sustained.
Do you understand that for charges to be issued that it has to be a claim, therefore it has to be a plaintiff?
Objection.
Grounds.
Okay, so first of all, the
Grounds.
grounds are relevancy. It's not relevant. That would be the
You
grounds.
also have to state the grounds.
Hold on. Let her get her position out, Mr. Brooks.
And it mischaracterizes the former testimony.
It does
Sustained
not.
as to both grounds.
So you're not sure if there's a plaintiff?
Objection,
Grounds.
relevance.
Sustained.
Have you ever had any interaction with the plaintiff?
Objection.
Grounds.
Sustained.
Are you aware who brought charges in this matter?
Objection,
Grounds.
Sustained.
If you're not sure of a complaint, how can you be sure of the charges in this case?
Objection.
Grounds.
Sustained. Mr. Brooks, under 90611, please move on to a new topic.
Your Honor, with all due respect, every question that I'm asking is relevant. It pertains to the plaintiff in this matter that seems to be nowhere
Mr. Brooks, you're making
found.
a legal argument. We'll take that up outside the presence of the jury. Move on.
I believe the jury deserves to know who the plaintiff is in this matter. How can they rule on something when they don't
Mr.
even know
Brooks?
who the plaintiff is?
Please, move on. Next question, or I will turn it back over to the state for redirect.
About how far from the vehicle were you when it passed you?
from the red SUV.
About how far from the vehicle were you when it passed you?
Can you tell me which vehicle you're talking about?
How far from the vehicle were you when it passed you? The vehicle that went around your Blazer's vehicle.
The red-
I guess I would ask the defendant to be more clear as to what vehicle and when it went around, like at the beginning of the parade, before it struck his kids.
I was just clear. I said the vehicle that went around his Blazer.
Sustained.
The vehicle that you observed approaching.
Objection, just to clarify, is he saying the red SUV or some other vehicle?
Sustained.
Well, I thought he was clear when he said that there
You
was
have to
only
be clear
one
with your
vehicle.
question, Mr. Brooks.
Excuse me, Your Honor?
You have to be clear with your question. It's
Well,
vague.
he
As
said
to
there
the
was only
word
one.
vehicle, you need to be clear which vehicle you're questioning the witness
The
about.
vehicle that was approaching, that he said
At
was
what
approaching.
point in time, what color is the vehicle, something like that.
Vehicle that you observed strike anyone. How close were you to that vehicle when it passed you?
The red SUV was about 10 feet probably from me.
And you didn't see the driver. Did you see anyone else in the vehicle?
I did not look in the vehicle.
Would it be fair to say that 10 feet from a vehicle is pretty close?
Subjective.
Would you say that's pretty close?
It depends what you're talking about.
Would you say that 10 feet is pretty close to a vehicle?
Depends. If they're driving, yes.
Would it be fair to say that that's close enough to be able to see who was driving?
It depends on many other factors.
What would those factors be?
Eyesight, windows up, down, if they're looking at the vehicle.
I'm assuming it would be fair to say that you were definitely looking at the vehicle. Any reason why you would not try to identify the driver?
Because my children were about to be struck.
Any reason why you would not try to see if you can catch a license plate number?
Because people had just been hit.
Sir, you had indicated that you submitted a claim to the Victim Witness Program for medical bills. Were those the medical bills for Caden and Riley that were incurred as a result of the red SUV hitting both of those children?
Objection. Relevant.
Overruled.
Did the vehicle, when it struck you, or after it struck you, continue on with its path of travel down the parade route?
Yes.
Overruled.
Could you tell if it went straight ahead, swerved one way or the other way?
No. Lead the witness.
Overruled.
What did you see in that video, sir?
Being struck.
Okay.
You may take the video down, please. All right, go ahead.
I'm going to need that same video.
All right, well, let me know when you need it. You may start your cross.
Can you pull that exhibit up again? Can you pause it right there? Can you identify for the jury where you are in this video? You can unpause it. All right. Have you seen this video before today?
Just still shots of it, not the video itself.
So it'd be fair to say that this is only your second time seeing this video.
Yes.
Do you, you can take the video down. Do you recall saying that you needed a walker to assist you in moving?
Yes.
Would it be fair to say that you're moving pretty good these days?
Objections or relevance?
Grounds.
Sustained.
Would it be fair to say that you're walking pretty good as of now?
Objection.
Grounds. Just walk to the
Sustained.
bench.
Not relevant.
But were you able to get a look at the driver in any way?
No.
A license plate number in any way?
No.
About how far was the vehicle away from you at that time that you observed it?
20 yards.
You were able to make that assumption how?
I'm a coach and we go off yards a lot.
That makes sense. So would you consider yourself to be an injured party in this matter?
Absolutely.
So you would consider yourself to be a plaintiff?
Objection.
Grounds.
Sustained.
Do you recall who called you to testify in this matter?
The DA.
Do you recall the name of the DA?
I got
Objections to relevance for this
Grounds.
hearing?
Sustained. He's already indicated that the district attorney's office issued the subpoena.
Well, actually, he said the DA, so that was pretty vague.
Sir, did you mean the district attorney's office?
Yes.
Next question, please.
Do you recall the name on the subpoena?
Objection.
Grounds.
Sustained.
So to the best of your knowledge, you're not aware of any plaintiff in this matter?
Objection.
Grounds.
Relevance.
Sustained.
To the best of your knowledge, you have never seen the plaintiff in this matter?
Objection.
Grounds.
Relevance.
Sustained.
Would it be fair to say that this matter has been going on for quite some time, that there were a lot of reports in the news?
Objection. Relevance.
Grounds.
Ms. Brooks, unless you can tie it into relevance with this witness, I'm inclined to sustain that objection.
I'm going somewhere with it. Did you at any time see any reports about the alleged defendant at any time?
Mr. Brooks. This is not a witness who identified the driver, so I'm not sure where the relevance is of this. We'll take it up outside the presence of the jury. All right, thank you. Be seated. Mr. Brooks, I cut you off when you were asking questions about what this witness had seen on the news. I'll give you an opportunity to give me an offer of proof as to why you believe that's relevant.
It's relevant because of how close he testified to being away from the vehicle. Being 20 yards away from the vehicle is not far enough that you wouldn't be able to see a driver or see into the car.
How does the news reports relate to that?
Maybe he may have seen the alleged defendant on the news, and maybe that may jog his memory back to if he seen the driver.
But he testified he didn't see the driver.
He also testified to never making the comment that he didn't remember the event, but it's clearly in his summary and in his report that he said his report is conflicting with what he's testifying. So I was trying to get at the credibility. That was my whole aim.
What does the news reports have to do with that?
The news reports are relevant just by the sheer amount of reporting that they've been reported. This has been going on for a year.
The news reports don't have any bearing on his credibility, but the questions you were asking don't further that theory. So that's why I cut you off.
With all due respect, Your Honor, a lot of the questions I asked are objected to. It seems like I can't even get to the questions that need to be answered.
Sir, many of your questions go to these sovereign ideas that are frivolous arguments about the plaintiff and all of that. I give you a little bit of leeway on it. Ask relevant questions, they'll be answered. Who's the next witness?
With all respect, on the record, Your Honor.
I've asked a question of the state. Let them answer, please.
Will I be able to...
Mr. Brooks? All right, we'll bring the jury back out and you may call.
On the record before you bring the jury.
Quickly, Mr. Brooks.
You made reference to questions I asked and being, you said something to the effect of sovereign things. I don't understand what you mean by that. I got enough work to do on the fly. I'm merely just... It was understood that this would be a whole new thing for me to do. I apologize if I'm not as polished as I should be working on 3 days' time before a trial. We see all the work that I have that I haven't even gone through.
Mr. Brooks, the jury's coming back in.
For the record, I don't consent to that name, and I don't consent to the arguments that prosecution made. There are relevant questions as the jury deserves
Mr. Brooks,
to know.
please.
The jury deserves to know who the plaintiff is in this matter. I think it's fair to them if they're to make an informed and intelligent decision, they should know who the plaintiff is.
Your objections noted for the record.
Will a legal finding of fact on that ruling, Your Honor? Or is that a judicial determination, Your Honor?
Thank you, everyone. Please be seated.
Was there a vehicle or a float associated with your group in the parade?
Yeah, there was a truck.
What kind of truck?
It was...
Pickup truck?
Yes.
Objection.
What's the objection?
Leaving the witness.
Her answer may stand.
About how many times did you make it through your routine during that parade?
Objection. Irrelevant.
Overruled.
Was there a certain point when your dancers stopped dancing?
Objection. Irrelevant.
Overruled.
Yeah, they did stop dancing.
I would move Exhibit 33 into evidence.
Before I allow that, if you could ask her about the non-labeled boxes.
Sure. You can see that there are some boxes on this diagram that don't have names in them. What do those boxes represent?
Who wasn't injured?
Objection. How is it legal to instruct the prosecution to ask a question that they should already know to ask?
Your objection is noted. It's overruled. Exhibit 33 is received and permission to publish is granted.
Do you recognize this video?
Not this video.
Did you recognize the people in front of the truck holding the banner?
Objection. The witness stated she doesn't recognize the video. How is it permitted?
Your objection is noted. It's overruled.
Does this video appear to be an accurate depiction of your group along the parade route?
Objection.
You may answer.
Yes.
I move to admit exhibit number 32.
I'm sorry, Your Honor. Did you sustain that objection
Which objection?
that I just objected to?
It was overruled.
Are you making that decision now?
There's been a request by the state to receive Exhibit 32.
I objected.
It's overruled.
On what
Exhibit.
grounds, Your Honor?
The foundation has been laid. Permission to publish is granted.
On what grounds, Your Honor?
The record speaks for itself.
On what grounds, Your Honor?
You may play.
We're going to play from the beginning. We're standing in the middle of your group. Were you on the left side or the right side?
Objection, leave.
Overruled.
After having watched that video just now in court, does it appear as though that diagram was an accurate depiction of where the named girls were positioned at the time the SUV came into the group?
Yes.
I'm sorry, what's the objection?
Hearsay.
Overruled.
Do you recognize images from the video?
It's...
Objection, hearsay.
Overruled.
Now do you recognize the video?
Yeah.
An accurate depiction of the scene as you saw it that day?
Mm-hmm.
Hearsay. She already stated she didn't recognize the video.
Your objection's overruled. It is not hearsay. And if you did answer, if you could just repeat
Is
it.
that video an accurate depiction of the scene as you saw it unfold that day?
Yes.
Objection.
Your answer may stand.
What was the answer?
Yes.
There's a figure on the left side of the screen, appears to be wearing black with long hair. You recognize that person?
Yes.
You can't even see any features
Mr.
in
Brooks,
there.
that's argumentative. It's overruled. You may answer.
Hearsay. Objection for
Not
hearsay.
hearsay.
Clear hearsay.
You may answer.
Yes.
Do you recognize that video?
Yes.
Move Exhibit 35 into evidence and request permission to publish.
Objection.
Permission to publish granted.
Objection. Who even took the video? Is it relevant?
It's not an objection.
Not even a witness that took.
So, Judge, I have to step in here and request that Mr. Brooks be instructed to stop making comments under his breath. This witness is very clearly having an emotional and difficult time testifying, and she doesn't need to hear that.
Objection. She can't hear anything I'm saying.
Mr. Brooks, the mics are very good in this courtroom, so please refrain.
You knew Vivian Darrell before November 21st. Do you recall seeing her either while the SUV was driving through or after?
Objection. Hearsay.
It's not hearsay. Overruled.
Can you describe the circumstances when you saw her after?
Objection. Hearsay.
Mr. Brooks, I'm going to direct your attention to review section 908.01. You have a statute book. It's not hearsay.
Do you remember talking about what happened to Sam? Did you see her in the days following this incident?
Objection. Irrelevant.
Overruled.
Right.
As soon as the day she was able to have a visitor, I was there.
When you say visitor, what do you mean? Where was she?
Objection. Irrelevant.
Overruled.
She was at Children's.
Children's Hospital? And you know she was injured as a result of what?
Objection. Hearsay.
Yes, she was there because she was struck.
You're not able to give an accurate estimate about how fast the SUV was traveling at that point, is that right?
I could.
Okay. If you think you can, please tell us how fast do you think it was traveling?
Objection, hearsay.
Overruled.
I thought around 55.
Many of your hearsay objections, they're not hearsay at all. And I hope you're not just saying them just to interpose an objection.
For the record, Your Honor, how do I know that prosecution isn't objecting to anything based on the same assumptions?
I don't understand what you're saying.
A lot of
You have to have
times,
statute books. If you'd like to read the hearsay statute, I realize you are not a lawyer, Mr. Brooks, but you still should have a good faith basis to make the objection. There was one I sustained because it was in fact calling for hearsay. But when a witness has knowledge, hold on, when a witness is not asked to say what another person has said, they have otherwise personal knowledge about something, they can provide that answer. So I'm hoping that's helpful to you as you formulate your objections. I just ask that when I rule on them, you not interpose the same objection before the witness has answered.
I'm now informed. I don't understand how someone can testify to things being told in the hospital. How would they know what injuries someone would have without being a parent or a direct relative? That would be hearsay.
Sir, again, people can testify based on personal knowledge. What's hearsay is when it comes into court and they say, so-and-so told me. Again, I think you're confusing personal knowledge with hearsay. I can't obviously further explain to you, sir, other than to say ignorance of the law is not something you can use as a valid kind of defense. You keep saying, I don't understand.
I don't.
You did this of your own free will. You waived your right to an attorney, and the ignorance that you claim is not valid at this point. So
I also
with that,
altered that contract, Your Honor. You accepted the contract in the way that I sent it back to you. Now let's
sir,
be
we don't
fair.
have a contract together. All right, we are in recess. All right, we'll go back on the record. In State versus Brooks, appearances are as they were this morning.
State that I do consent to that name, nor do I know any individual by that name.
Your lack of consent is noted for the record.
On the record, before the jury comes out, I would like to direct Your Honor to a case, United States versus Cotton, 535.
Mr. Brooks, if you have a motion, you need to put it in writing. So if you're asking me to reconsider something, you need to follow the proper procedure.
What is the proper procedure, Your Honor?
I've told you repeatedly what a motion is. If it's a reconsideration, 806.07 is the statute.
It's not a reconsideration. It's just bringing up the subject matter jurisdiction again. Which
Sir, I've already dealt with this repeatedly. So any further times you want me to address it, you need to put it in writing.
I have that here, Your Honor.
Not just simply a case. I want a motion.
I've put in several motions that have yet to be
Sir,
answered.
I've already addressed them. I'm not going to delay the start of this cross-examination for this argument yet again.
It's not
I've already addressed it. The fact that it's the afternoon doesn't mean I need to address it again. Jury's coming out.
It's going to continue to be brought up. It's going to continue to be brought up. Subject matter jurisdiction can't be forfeited or waived. You know that. By not answering, Your Honor.
Please, the jury's coming out.
By not answering, Your Honor, you're agreeing to a tactic agreement. Is that a judicial determination that you don't have to answer? I'll take that as a yes.
All right, Mr. Brooks, you may question the witness if you have any questions for her.
I don't consent to being called that name, as I stated before. I will note that, like that noted for the
Defendant can
record.
question the witness then.
Is that noted for the record, Your Honor?
Ask your questions, please.
Is it noted for the record, Your Honor? It was a few exhibits that you stated on record that you weren't familiar with seeing. Would that be fair to say?
Once clarified, I did say that I remembered seeing them.
Do you recall who showed them to you?
Yes.
You stated for the record and for the jury?
Can you repeat that?
Can you state who showed you the videos for the record and for the jury?
The state.
Who would you be referring to when you say the state?
The three seated next to you.
Are you referring to the opposite table next to me?
Yes.
Let the record reflect that. She identified the three prosecutors sitting at the prosecution table. You didn't try to see if you can spot a license plate at any time.
It all happened way too fast.
In regards to your dance team, did you observe anyone struck?
I can't say I remember seeing a vehicle hit them. I remember seeing bodies in the air and on the ground.
At that point, it would be fair to say that You didn't know if the people that were on the ground or in the air were in fact struck by a vehicle?
Well, I did know it was the vehicle because I turned around and I saw the vehicle coming towards them, and then I think I blacked out.
Was that the first time that you ever had a blackout?
Yeah.
Any idea what caused it on that occasion?
Stress. Shock.
Do you recall at any time reading or seeing a complaint in this matter?
No.
Do you recall at any time filing any claim in this matter?
No.
Would you consider yourself a party to this matter?
Objection.
Grounds.
Sustained.
Do you recall if you were contacted by the plaintiff in this matter?
Objection.
Grounds.
Relevance.
Grounds.
Can you say who the plaintiff is?
I'm asking you, are you aware of the plaintiff? Were you contacted by the plaintiff at any time?
I don't know what the plaintiff is.
The plaintiff would be whoever is bringing the claim for the charges in the matter.
Then, yeah.
Objection.
Yeah, what? You were contacted by the plaintiff?
Objection.
She answered yes. I'll ask her grounds.
Objection. Hold on.
Objection. Move to strike.
Grounds.
Legal analysis.
Grounds.
I'll sustain the objection.
Who were you contacted about testifying?
The state.
I'm assuming the state of Wisconsin, correct?
I just know them as the state. Right there.
Right there, as in referring to the prosecution table?
Correct.
To let the record show that she identified the state as the 3 attorneys at the prosecution table. Would it be fair to say that you would identify the state as the plaintiff in this matter?
Objection.
Grounds.
Sustained.
Have you ever had any interactions with the plaintiff in this matter?
Objection.
Grounds.
Relevance.
Sustained.
Do you see the plaintiff in the courtroom today?
Same objection.
Grounds.
Sustained.
Do you even know if there's a plaintiff?
Same objection.
Grounds.
Sustained.
In your opinion, who would you say is the plaintiff in this matter?
Objection.
Grounds.
Sustained.
Are you still currently a member of the dance team? What is it, Extreme Dance Team?
Yeah, I do not work there anymore.
And was that decision made by the incident, or was it just a personal decision?
Objection.
Grounds.
Sustained.
With respect to that blackout, you testified that you don't have a visual memory of the SUV actually striking any girls that day. You do have a visual memory of the immediate aftermath of the strike?
I do.
Overruled.
And what is that memory?
Objection. Hearsay.
It's overruled.
People screaming, running around, just chaos.
When asked on cross-examination what caused your blackout, you said stress and shock. At any time in your life before November 21st of 2021, had you ever witnessed an SUV drive through a group of young women?
Objection. Hearsay.
Overruled.
Objection. Relevancy.
Overruled.
What about any time since November 21st, 2021?
Objection. Relevancy.
Overruled.
No.
Your Honor, is the video playing at the right speed?
We'll double check for Mr. Brooks. Can we make sure that we've got it at 100%? Yep.
It just wasn't. It had to be turned up. So that means when it was just showed, it wasn't playing at the right speed.
I think I can just very simply clarify. To adjust the speed, you have to change it to see what it's set at. So it was at 100%, and it is now back at 100%.
I object to that for the record. It clearly wasn't at the right speed.
Go ahead.
Objection.
You know who Charlotte Urell is?
Yes.
Can you explain for us her relationship to the Extreme Dance Group?
Objection. Relevant.
Overruled.
She is the older sister of 2 of the Waukesha Extreme Dancers.
And did you make any observations of Charlotte at that time?
She was on crutches.
Do you know why she was on crutches?
Objection.
She was hit by the car.
What are we looking at here?
A red SUV that is smashed up. And there's a white light up headband on what used to be the side mirror.
Do you recognize that white light up headband?
Yes.
What is it?
Objection. Hearsay.
Overruled.
One of the headbands that was over our girls' white Santa hats.
Any questions for this witness?
Yeah. What type of vehicle did you actually see, an SUV or a car?
It was an SUV.
Any reason why you would refer to it as car?
I refer to all cars as just cars, no matter what they are.
Would it be fair to say that certain vehicles look different than others?
Absolutely.
Or were you able to identify a license plate number?
No.
Do you recall in your written statement saying that it seemed as if something was wrong with the vehicle?
Yes.
From your recollection, what would you say was wrong with the vehicle?
I thought maybe there was brake failure happening because it was going so fast.
And what made you come to that conclusion?
Because there was a car driving through a parade instead of slowly rolling through like the other vehicles.
By how long would you approximate you watched the travel of the vehicle after it had passed you?
I didn't watch the vehicle after it went past me. I was looking at the dancers on the ground.
You're measuring distance and time.
Yes.
And from that, you're calculating speed.
Yes.
What's your ultimate conclusion?
33.7 to 34.6 miles per hour.
You stated earlier sometimes you may encounter problems with the estimation. Would that be fair to say?
No, I don't believe that was my testimony.
You testify sometimes exact timing of speed could be a little inaccurate.
No, I don't believe that properly characterizes.
What were you referring to?
From frame to frame, it could change by a millisecond, hundreds of milliseconds.
So there can be sometimes miscalculations.
I don't believe so in the way we performed it, no.
Before this occasion, had you used the same method that you used for this occasion?
Yes.
How many times?
I had not used it in a live case yet. This was our first chance to do this.
Would it be fair to say that usually anyone's first time using new technology, there would be a learning curve?
I would say no.
So you would say you came right into using this new technology the first time you've ever personally used it and knew exactly how to work it?
I would say over my career, especially what had over 1,500 digital forensic examination aspects, I'm certified trainer, computer examiner certification through the International Association of Computer Certifications as well. The company I put on the training certification from input for this process for this device for video analysis principles and throughout all the different disciplines. And the training's intensive, quite difficult. And so over that time, you develop the skills necessary to be able to start using software or techniques to do investigations right away.
You're stating some pretty nice credentials there, but you also just said that there's some difficulty in the training. Would any of that difficulty lean towards the learning curve?
In my opinion, for myself, no.
So you can come into new technology and just know exactly how to work it, you're just ready to go?
Objection, argumentative, and
Grounds.
answered.
Grounds. So let me back up a bit. Around what time did you do this analysis?
Somewhere around the middle of August.
Any idea why so long?
Objection, asked and answered.
Grounds.
In the last 3 to 5 minutes.
Grounds. Sometimes things can get expensive. Would that apply to why the delay was so long?
Objection.
Grounds.
Relevance.
Grounds. It's basically who taught you to do it. I'm quite sure you're not the only person that does what you does out of your department. Would that be fair to say?
No, that would not be fair. I am currently right now the only one certified in forensic video analysis.
So who tapped you to be the video analysis for this particular case? Who contacted your agency?
Detective Casey.
Was Detective Casey made aware that it would be a long delay before the analysis can get completed?
Yes.
Was Detective Casey informed that it would be such a lengthy delay? Grounds. Were there any suggestions that maybe you could use a different technology that wouldn't have caused such a long delay?
Not for video analysis, no.
I'm a little confused because do you do video and speed analysis or one of the other? Did you just not state that this was pertaining to speed analysis?
I am trained to measure speed from strictly video analysis.
So how were you able to come up with an analysis of the speed in this investigation?
Based on the technique that I described earlier in my testimony.
Well, let me back up. Was there any other technology that you could have utilized that same method without a delay?
Objection, asked and answered.
Grounds.
Sustained.
So it'd be fair to say you yourself haven't done very many speed analysis.
I couldn't give you a firm number of how many we did, but no.
Not we, you. I'm asking specific to you yourself.
Outside of this current investigation, I have not currently performed any for any other agency yet, no.
So would it be fair to say that maybe you could have been off on a few of your analysis?
No, I would not say that.
Grounds?
Argumentative.
Hold on.
Calls for speculation and argumentative.
Grounds. Better grounds than that. Is it fair to say that someone else a little more experienced could have been tapped to do the speed analysis instead of yourself?
We didn't have anybody more experienced for this particular method.
Is it possible that a different agency could have been tapped to do the speed analysis?
Objection. This is outside of the witness's
Grounds.
personal knowledge.
Grounds.
Sustained as to the form of the question.
Would it be fair to say that you weren't the only one being trained through video and the like?
Sorry, I don't understand the question.
You stated the classes were, I think, from somewhere from May to August. Were you the only person that was taking those classes?
There were people from other countries, other states.
Anybody in Wisconsin?
Not that I know of, no.
So it would be fair to say that you're not sure.
I have not heard of anybody else in this area having the ability to do the speed analysis through video.
So it would be fair to say you're not sure.
As to, could you clarify one more time, please?
I was pretty direct.
Mr. Brooks asked
As far,
he doesn't understand your question. That's why he's asking.
did you know of anyone else that was taking the same training to operate the same equipment and technology that you were?
Personally, no.
So it would be fair to say that you're not sure.
I can say with confidence that nobody in the classes that I was enrolled in were from the state of Wisconsin.
And how did you come to that conclusion?
Typically, during our classes, we go through an introduction, where we're from, where we work, who we work for.
Because you did state that they were kind of like video, so I'm assuming that would be online. So it would pretty much be like a classroom from an online setting.
Objection. Asked and answered, and I would, relevance.
Grounds.
It's been asked and answered. Sustained.
Do you recall about what date you started the analysis?
Asked and answered.
Grounds. So when did you actually start to do the analysis? What date was that?
Same objection.
Grounds.
Sustained.
If you were to clean slate, take that video file, start your calculations here today, would you come to the same conclusion in terms of miles per hour over those 26 frames?
Yes.
Objection, hearsay.
We're behind. I'll be very honest. Today has gone much slower than we anticipated on cross-examination. We can shift things a little bit.
Any questions, Mr. Brooks?
Again, you know I'm going to say I don't consent to that name, but no questions.
All right, thank you.
Perfect time for the record to address that subject matter. Your jurisdiction, Your Honor. Perfect time.
The request to address it is denied.
Is that a judicial determination, Your Honor?
It's denied.
Is that
I'm not going to address it right now. I've addressed it previously. There's no new information. Denied.
Is it a judicial determination you're making, Your Honor?
The jury's coming out.
Is that a judicial determination, Your Honor? It's a tacit agreement. It's a tacit agreement.
Is this an accurate depiction of how you looked that day?
Yes.
Isaac as well?
Yes.
Move Exhibit 43 into evidence and ask to publish.
Objection. Where are they in the video?
Permission to publish is granted.
Objection on that last exhibit.
We'll take that up outside the presence of the jury. Don't let me forget. All right, then go ahead if you have any cross for this witness.
You stated that you went to the urgent care in Pewaukee the next day. What caused the day delay?
I knew I was hurt, but I did not need immediate attention as other people did.
So you had went home for the evening and decided to just go to urgent care the next day?
Yes.
Any reason why you didn't take your son to seek immediate attention?
He was able to walk out of there with me, so that's why we decided to wait until the next day.
When you and your son were treated for your injuries, about how long did the treatment last before you were discharged?
We were there for at least an hour.
And why so briefly?
Objection.
Grounds.
Argumentative, sustained.
Do you recall if you were wearing a winter cap?
I do.
Do you recall if you had it pulled low, possibly over your ears?
No.
You don't recall?
I was wearing a headband. I was not wearing a cap.
It'd be fair to just say that you just said you was wearing a cap.
No. You asked if I recalled if I was wearing one. I said yes, I recall.
That you were wearing a cap?
I recall if I was. And it was a winter headband.
I might have been confused. I apologize.
Ask the next question, please.
I don't consent to that name, Your Honor, for the record.
What group was in front of you at the moment that the SUV got to your family?
Extreme dance.
Did you see those girls get hit?
I did.
based on what you saw with those girls getting hit, if you and Isaac had been standing 18 inches to the north, do you think you would have delayed until the next day to seek medical treatment?
Objection, that's subjective.
Sustained.
I don't have anything else for this witness. Thank you.
All right, Mr. Brooks, I cut you off because I wanted you to raise whatever the issue was outside the presence of the jury.
I forgot what part you cut me off on.
Any other issues from either party?
We still got the issue about the 13th subpoena.
The state's not obligated to make any kind of travel arrangements or otherwise serve the subpoena on someone who's out of state. You're put in the same position as an attorney who's been practicing here in the state of Wisconsin.
For the record, I have to be licensed to be held to the same standard as a licensed attorney. I don't want to get into that because I don't want you to think I'm trying to argue.
I disagree with your legal assessment, sir.
I intended to have 13 witnesses. I'm obviously not able to call the 13th witness. How do I get my 13th witness?
I can't answer that, sir.
Would I still be able to have a 13th witness?
Who would be your 13th witness then?
I would have to look on my original witness list. I know that was my target, was 13.
I'll let you look through that tonight and you can advise us in the morning.
I do want to state also for the record why I'm able to hear you very well is because I'm actually in the courtroom with you, which I have been the last few days, which is a breath of fresh air. That's why I'm able to hear much more clearly.
All right, thank you for making that record. I appreciate it. Any other issues from the state?
Nothing, Judge. Thank you.
All right, we'll see everyone then tomorrow morning at 8:30. We are in recess for the day.